SJC-11077, Commonwealth v. Jabri, Jordan, Copney.
Yes, counsel. Good morning.
Good morning, Mr. Chief Justice, and may it please the court. May I reserve 3 minutes for rebuttal?
You may.
Your Honors, what I propose to do this morning is address the prior bad acts issue first, and then address the denial of the defendant's motion for mistrial and any remaining time. I'll spend a couple minutes on the suppression motion. This case raises the issue of whether this court or any court can rely on limiting instructions and curative instructions in extreme circumstances. In the issue about the prior bad acts, essentially the jury heard over the defendant's repeated objections that this defendant committed the same crime, essentially the same crime, if believed, 6 months before the incident in this case. And there was a limiting instruction, and I would suggest to this court that that limiting instruction under these circumstances, with this extreme situation, had no likelihood of success. What
was the defense here?
His defense was that it was a drug deal that went bad, that he was there to purchase drugs, and the Commonwealth's chief witness shot the drug dealer. That was the defense.
He's saying Mr. Jiggets did the shooting?
That's right. That's right. That was the defense, and there were some other ballistics.
So doesn't that make the prior incident pretty relevant?
But how would the jury deal? It's logic in terms of Wigmore's logical relevance. It's very relevant. The problem is that no jury could ever properly digest or handle that kind of evidence. What they would do, any juror would think, well, he did this 6 months ago. He's a drug dealer. This guy is a drug dealer, and if he did it that time, he did it this time. And I would suggest that no jury could have ever dealt with this.
Even though the judge told him exactly the opposite.
Absolutely,
you
yes.
cannot use this to conclude that he did use that prior situation to conclude he committed this crime.
Yes, yes. And Wigmore talks about this, and this is one of the most written about areas in the law of evidence. And the judge, you're correct, Your Honor, there was a limiting instruction. He said, you can't use this, and he asked the jurors about it.
Let me just make sure I understand your position. You're not saying that prior bad acts should never come in. You're saying there are especially bad prior bad acts that should not come in.
I think that's a fair statement. Yes, and this one was so close in time, 6 months, and it was virtually identical circumstances.
But isn't that the point, though?
Well, it may be.
But in terms of pattern of behavior.
Well, certainly that's why the Commonwealth introduced the evidence. The question is, could a jury properly use that evidence, or was that an invitation to come to a verdict based on an emotional judgment in the case? Are they punishing him for because he's an evil person, because of what he's done in the past? Or are they punishing him? Are they finding a verdict based on what happened in this particular case?
But the strength of the prior bad act in terms of its relevance is that it's the same modus operandi. He arranges a drug deal with somebody for roughly the same amount of weight. He uses Jiggets as the strong arm, the guy who pulls out the gun. He gets him to a location which allows him to pull it off. He basically did the exact same MO 6 months later with Mr. Copney.
Right.
I'm sorry, with the victim.
Mr. Cosby.
The problem is that the question is not whether it's prejudicial. It sounds like it was devastatingly prejudicial. The question is whether it's unfairly prejudicial, and that has to be your burden to show that it was unfairly prejudicial.
Well, if you take a look at the evidentiary alternatives, the Commonwealth had lots of other evidence. And I have it in a footnote. In footnote 53, I listed all the other evidentiary alternatives that they had to prove intent, to prove the defendant's intent in this case. This evidence was not necessary.
Does that evidence include the most powerful stuff like Jiggett's and Campbell's testimony?
Oh, sure, but
But they've got big problems as witnesses.
they have problems with witnesses. The Commonwealth was left to rely on some witnesses who were unsavory. I think that's a fair statement. The record clearly supports that. But nonetheless, if you look at this evidence in isolation, you say, well, you know, there is some argument for letting it in. But when you look at the alternatives, and if you discount the probative value of this evidence by the fact that they had all these other witnesses, they didn't need it. And if they didn't need it, why was the jury invited to come why did Judge Liu take the risk of letting this evidence in the first place? And you have to ask yourself that. Matter of fact, one of the things,
I'm a little bit lost here. So your argument is the evidence was so overwhelming that he should not have done it, but if the evidence is that overwhelming, how could it have been prejudicial?
well, there still was the issue of whether these witnesses were to be believed. Okay. Without this evidence, at least the defendant would have a fair chance of trying to convince them as to his theory of the case. Sure, it was very similar, and it was clearly prejudicial evidence. All evidence from the Commonwealth is
Is that what unfairly
prejudicial.
prejudicial means? That you have that the judge has an obligation to make sure it's a level playing field in terms of the weight of the evidence?
No, unfairly prejudicial means that the jury is not going to base its verdict on improper grounds or on an emotional basis. That's what unfairly prejudicial means. I think there's case law that says that. I think I got that quoted somewhere in my brief. But nonetheless, one of the questions that I would suggest you ought to consider is if this evidence came in this case, where you have a very, very similar incident close in time, where do you draw the line? I mean, you have to ask yourself, does all prior bad act evidence come in? This would have, an average juror listening to this would either say whether he admitted or not to himself, and whether he promised Judge Liu or not that he wouldn't use it inappropriately. It would be I would suggest no rational juror could put this out of their mind.
So we have to conclude that the jurors would not follow the judge's instruction.
That's correct. Absolutely correct. They couldn't follow his instructions. You know, you look at if you take a look at the.
Well, would you then, from that, assume that in all our cases where we say we assume the jury followed the judge's instructions, that if they don't follow instructions when we're talking about prior bad acts, they don't follow the instructions when we're talking about other subjects as well? We have to assume jurors follow the instructions.
That is the going back to Bruton. That is the argument from the Bruton case with co-defendant confessions. That we're going to have joint trials, therefore we have to assume the juries are going to follow the instructions and not use the evidence improperly. Courts rely on limiting instruction, no question about it. On the other hand, the trial judge has to make a reasonable determination whether this evidence was appropriate to ever get to the jury. That's what the law of evidence is all about. It's a filtering process.
But why wouldn't it be appropriate if it, in fact, was so pertinent to methods of operation, modus operandi, and that in turn goes to the intent? Was it an intent to just do a drug deal, or was it an intent to kill?
Well, the best way for me to answer that is it relevant? Yes. Is it incapable? Is it unfairly prejudicial? Yes, and it should not have gotten to the jury based on whether this resulted in
You got a
an
case that's
unfair
like
trial.
this?
I have not couldn't find cases exact like this because this case is so extreme. I think this is an
Insofar as
extreme case.
Insofar as this act resembles the prior act so greatly?
I could not find cases that were this extreme.
What I'm trying to get at is, what do you mean by extreme?
Close in time, exactly the same facts got to the jury. That's what I meant. That's what I mean. I think this case is an outlier. And that's why, and that's why this issue was probably the most litigated issue in the case.
Was the defendant convicted or charged of the crime regarding the Yale student?
He was indicted for that, but they null-prossed it.
That would have been in Connecticut?
That's right. That's absolutely, that's
Or
correct.
in New York?
Well, the issue was plan. I mean, I'm trying to guess at what the Commonwealth's theory was because we didn't have a trial on it. But the thinking possibly could have been, well, the planning for the crime occurred in Massachusetts, even though the actual crime took place in New York. But he was indicted for that, and it was null-prossed.
Indicted here or in New York?
Pardon?
Indicted here or in New York?
No, indicted here.
Oh, indicted here.
He was indicted here. It's one of the indictments. I believe it's one of the it's listed in my statement of the case. Let me unless the court has any further questions, I'd like to move on to the denial of the mistrial. This is another example of use of curative instructions, where curative instructions, I would argue, do not work. Basically, what happened was the defendant cross-examined a Cambridge detective and set up a Bowden defense. And he went and asked, "Did you do this? Did you do that? Did you do this? Do that?" Right? Basically, to show the jury that the Jiggett's story was not believable. And so the Commonwealth gets up and one question, and I'm going to quote it: "Detective, while you were at the taped interview with Mr. Aquino, did he indicate who had admitted to being the shooter?"
No, there was no answer to the question. And didn't the judge jump right in and tell the jury that the fact that there was no answer, they shouldn't draw any conclusions? I can't recall the exact words.
No,
but
that's
I'm
pretty
sure
close.
you-
That's pretty close. That's pretty close. But there was an objection first. The defense counsel, I mean, many cases talk about what was the reaction of, what does the record show defense counsel's reaction? Defense counsel went nuclear on this one, especially after all the prior bad act evidence came in. He said, what they did was they put in front of the jury, by suggestion at least, that the defendant confessed to the crime. And that's a hard one for jurors to put out of their mind. And there's I can't quote it exactly, but defense counsel said, he said poison the jury, but he said, you don't have to be Einstein to figure out who he's saying confessed. So, and Judge Liu gave it.
Have we ever said that a judge abuses his or her discretion in not calling a mistrial with regard to a question that was asked but not answered?
I don't know if there's a case on that, but this is a good case for you to do that. That's all I can say. I mean, this,
Time, right?
for the first time. There's always a first time for everything, Justice Bosworth. Anyway, this, yeah, again, you ask, can curative, do we rely on curative instructions like this? This is another one hard, especially combined, and when you do your 33E review, you combine this one with the prior bad acts, and you start asking yourself, was this a fair trial? Let me briefly address in my time remaining, the suppression motion. The first point I want to make is that Judge Gershengorn ruled that the defendant was essentially a squatter, those are her words, and didn't have a reasonable expectation of privacy. Well, there's a Supreme Court case, Minnesota versus Olson, which basically says, if you're an overnight guest, that suffices. You have a reasonable expectation of privacy, and the record is clear that this defendant was.
But that was one where society was prepared to recognize that as reasonable, whereas here, the question of this kind of staying over when Harvard has rules and regulations that prohibit this, is not necessarily in the same category at all.
I would disagree, respectfully disagree.
Sure, it
Basically,
was the homeowner in Olson, it was the homeowner who let that
Right.
person stay overnight. Here, the young woman had no authority to allow him to stay for that period of time.
Well, maybe Ms. Smith was in trouble with Harvard, but I don't think we should. This court should use Harvard's own rules and regulations on student housing. Should federalize them and make them into and give them constitutional significance. This person clearly was a house guest for weeks. I mean, there's no question that there's evidence in the record of that, and with the consent of. If she is a lessee, I don't know whether Harvard's dormitory leases rise to the level of a traditional landlord-tenant law. But nonetheless, he was an overnight guest with her permission. And I would suggest that from a reasonable expectation, he certainly thought, and I think society would agree, if I were staying in, or any of you were guests in a Harvard dormitory overnight, that you had a reasonable expectation of privacy. Whether he stayed too long, whether she should have booted him out, that's a different issue.
Let's assume you're right. Let's assume he had a reasonable expectation of privacy. Then he says, I'm leaving, I'm going. Does he retain that expectation of privacy even after he has left and has gone to New York?
Well,
Because I
that's
gather
the abandonment
occurred
question.
the morning after he had left, correct? Or the day after he had left?
I'm sorry.
The search occurred the day after he had left for New York, correct?
He got arrested, I think, the day after, and that's when he came back to Boston. That's my recollection.
But the search occurred. He leaves for New York the day of the killing, correct?
Yeah. Oh, yes. Yes, you're
And
correct.
this search occurs, obviously, after that.
Yes.
And probably, I think, the next day.
I think it's the next day. I think that's right.
Okay, so he's already, if he's an overnight guest, he's gone. He's no longer an overnight guest on the day of the search.
He did not have a short-term. He was not a short-term guest. I think that's probably the best way to describe it. He has clothes there. He was there for weeks and weeks and for almost from the beginning of the semester.
Well, what about the alternative of that it really was an emergency because nobody could find Ms. Smith?
Well, let me address that. This was not the Entwistle case. That's probably the best way to describe it. You didn't. This was an active. I see my time is out. May I conclude that thought?
You certainly can.
Okay.
Yes.
This was not the Entwistle case. This was an active criminal investigation. They knew that Brittany Smith's ID card was used to open the doors. If anything, I think objectively, the police officer would say she was involved. She was in on it. She was a joint venturer, a la Mr. Zanetti. And one last point, a college student gone for 24 hours is missing. I just think that's questionable, and I'll sit down at this point.
Thank you.
Good morning. My name is Michael Caney. I'm an assistant district attorney from Middlesex on behalf of the Commonwealth. With me is David Sollett, who is one of the two trial attorneys on the case. I'll just pick up where discussion was left off on the emergency aid grounds. I think Entwistle is the best case for resolving this. Entwistle says itself as to that first entry in Entwistle, you may recall there were two entries made, that all that is required is a reasonable basis to believe that something unfortunate might have happened that rendered the occupant of the house unable to communicate. And in Entwistle, there was, of course, no sign of criminal activity, no sign of violence. Essentially, the family had been missing for something like 8 hours, missed a lunch date, missed a dinner date, and there was a pampered dog inside who had been abandoned.
That's different right away from this case, where everyone knew that someone had been killed.
Exactly, Your Honor.
And-
That's my point, that there was a much higher risk in this case. That the fact that Ms. Smith might have been inside the dorm room and injured, or that there might be others in there, were much more dramatic risks here. Here we had a victim who was dead by shooting. We had the victim's repeated cell phone calls to Ms. Smith's telephone in the minutes leading up to the shooting. We had her key card being used to access the basement where the shooting took place. Over the course of 24 hours, there was no response from Ms. Smith, from repeated telephone calls, from knocks on her door, and from a phone call placed by the dean of her residential college, who was particularly concerned because in the past she had called him back immediately. I would say that the factors in this case were much more compelling, that there was a potential risk to the occupant than in Entwistle.
So Judge Gershengorn conducted an evidentiary hearing?
Yes, she did.
And did she make findings that suggested what it was that the police were doing when they went into the room?
Yes, she-
In that regard? I mean, because you could also look at the very same facts and say that this was just all part of a criminal investigation.
Well, Your Honor, the evaluation is objective. So whether this is a little different from the community caretaking function, as I understand it. So whether or not the investigation was also for the criminal investigation, that's not a bar to the application of the doctrine, since it's an objective measure whether there would have been cause for concern. And I think that's clear from the Supreme Court case Brigham City, where the officers in fact observed a criminal act through the window and then went in to provide aid. But the judge did in fact find that the officers had gone in under the emergency aid, that they were concerned that she was injured, and that it also was consistent with the Harvard University policy to make well-being checks. As to the abandonment of whatever interest the defendant had in the dormitory room, I would just point the court in the direction of Commonwealth versus Pasco, 393 Mass 164, and Commonwealth versus Mallory, which is 56 Mass Appeals Court 153. They're both noted in the brief. Those are cases, in Pasco, it's a motel room. In Mallory, it's a bedroom that the defendant was renting in a private home. In both those cases, defendants fled. In Mallory, it was from the crime scene itself, which was the bedroom, and the same day, the court found in both cases the properties had been abandoned. So I would say those control the situation here, where the defendant left the university within minutes of the shooting, traveled to New York City, and didn't return until the time of his arrest. Going back to the prior bad acts evidence, where defense counsel started, I would just like to point out, and this is in the brief, that the judge here took extraordinary measures. He did not instruct the jury on the limited purpose once. He instructed the jury 5 times on the limited purpose for which they could use this evidence. He did it before the trial. He did it when the evidence came in, and then, of course, he gave it a final instruction. And beyond that, he developed, and it's included in the supplemental record appendix, special voir dire questions to qualify the entire jury pool. And he, on his own, excused 12 jurors for cause because he wasn't convinced that they could, in fact, apply evidence for a limited purpose. That was really an extraordinary measure. He also had pretrial argument, and there were memoranda submitted on the question. He conducted a voir dire of the witnesses, and he heard additional argument during trial. And when the evidence came in, he was clear that it was to be limited and sanitized. So I think he took really unusual measures here to make sure that the evidence wasn't improperly applied.
You know, there's a couple of cases where Justice O'Connor of this court, in some dissents, points out the dilemma of prior bad acts cases, prior bad acts evidence, where if this Yale incident involving the Yale student in New York had gone to prosecution and a conviction, had he been convicted of it, you probably couldn't have put that evidence in.
And what would there?
Because it would have been too similar.
I think that rule would apply if it was for impeachment purposes, Your Honor. I'm
I
not.
think you could have gotten that evidence in even if there had been a conviction.
It's a question I haven't considered because it doesn't apply to the case. But in the
I understand.
hypothetical,
But I mean, in trying to figure out, you know, where the limits of prior bad act evidence is, it's something to think about.
And I am aware of that is a weighing that's done in when convictions are interest for impeachment. I'm not aware of cases limiting it in this circumstance, Your Honor. I think really the question that defense counsel has presented is, does Helfand really say what it says Does it really mean what it says it does? Whether it's permissible to use prior bad acts to prove intent or any of the other things that we use them for, whether a judge really has discretion to do the weighing here, and whether the court can presume that jurors follow instructions on limited use. Defense counsel has said very clearly today that, at least as to the third factor, he doesn't think this court can consider that jurors do follow those instructions. And if even in this circumstance where they were handpicked, both by the judge and also by defense counsel, who also asked his own question on jury voir dire to see if he was satisfied that the jurors could follow these instructions. The defendant says no. The defendant says change Helfand, change it in three ways. First, he proposes that the court reverses the formula so that the probative value must substantially outweigh the potential for unfair prejudice to the defendant. That's at the defendant's brief, page 29, and of course that's a reversal of the established formula. He also asks that the court severely restrict the judge's discretion to admit this evidence where there is some other evidence of intent. I guess under the defendant's rule, a single point of evidence would be enough, no matter the quality of that evidence, no matter the care the judge uses in admitting. And I would suggest that that's clearly not the rule now, and I think it's a rule that couldn't be administered. Here, the entire trial turned on the question of intent. I think this falls exactly within Helfand. And in fact, I think Helfand was a closer question for the court there. I mean, those were incidents that took place 3 years earlier, and the drugging and sexual assault in the earlier cases was admissible. It was a very narrow instruction. It was admissible only as to a drugging charge in the subsequent, in the case that was on trial. And so you were really asking the jury in that case to say, well, here are some prior incidents of drugging and rape. This is a rape trial, but we only want you to consider those for the drugging. I think that is a narrower needle to thread than here, particularly given the qualifications that were made by the judge. I think the other thing I wanted to touch on was defense counsel's discussion of the motion for the mistrial here. It's clear that in Amaral and in Bryant, two cases cited in the Commonwealth's brief, those are cases where answers were given to questions that were objectionable, and the court didn't hesitate from saying that a curative instruction was sufficient. Here, the judge struck the question immediately. He instructed the jury immediately that questions were not evidence. In Bryant, I think actually they sat over a long Thanksgiving weekend before the judge issued that instruction. Twice more in this case, both in the opening instructions, pretrial instructions, and also in closing, the judge additionally instructed the jurors that questions were not evidence, and he also instructed them that an answer struck is not evidence. So you'd really be overturning quite a lot of law if you were to decide in this case that an unanswered question, fully instructed, was a cause to reverse a conviction.
Now, can I ask you a question? On page 36, you suggest that the judge didn't even really have to sustain that objection. And I really don't understand your argument. Could you?
Yes, Your Honor.
You somehow think that this was when it was an okay question to ask.
Well, I think it's very similar to the circumstances of Avila, which is the case that I cite at that point, Your Honor. In that case, the primary witness for the Commonwealth had given multiple statements. He was essentially a co-venturer similar to this circumstance, and he was under attack. The police were under attack for why did you credit this sketchy character's story, particularly when there was some evidence suggesting, well, quite a bit of evidence indicating that he was involved in the murder himself. The officer was asked on the stand essentially that questions leading to explain why they credited his testimony, and the officer was permitted to testify that others had provided other information that was consistent with that account. So although the fact that the witness had given varying statements in the course of the investigation, the other evidence confirmed his version. That's all that was really going on here. In this case.
I don't really know the circumstances of the other case, but here, of course, that witness was one that the Commonwealth refused to call a trial.
Yes,
And so this would be a way of getting something in that you couldn't otherwise have gotten in.
The jury was fully instructed that this was coming in only for the purpose of the investigation, only essentially for what was the thoughts in the police investigator's mind at the time and whether their course of action was justified. So essentially there had been an attack on why did the Commonwealth credit Jiggets, who was clearly implicated in the crime? Why did you only accept his version of the facts and not pursue a different,
Aquino
other versions? Aquino and Jiggets. The three were Aquino, Jiggets.
testified because he had a cooperation agreement.
That's right.
But
And so,
Aquino was somebody that the Commonwealth refused to call.
so the evidence was.
And this was a reference to Aquino, not to
It was
Jiggets.
yes, Your Honor. It was a reference to Aquino. So the question was why, essentially the question was why were the police warranted in crediting Jigget's story? And the answer would have been because before we ever spoke with Jiggets, Aquino had given us a consistent account and also reported the defendant's admission to the shooting. And I suggest that's really essentially what went on in Avila also. And in any event, here the statement, the defendant's statement that he was the shooter came in Jigget's testimony anyway, so at the most it would have been cumulative. The only other issue, I guess.
I'm sorry, in Jigget's testimony, Jigget said Aquino had said this?
No, I'm sorry. Jigget's testified that the defendant admitted to the shooting.
Right.
So
but
the
it's not
to the
really
extent the admission
cumulative.
was prejudicial, it was also
said he told him, okay.
in through other ways.
All right, but we don't, the judge sustained it, so
That's correct. Yes, so it was a long discussion.
to adopt your view of whether or not it would have been appropriate to
Yeah,
answer.
yes, and that's correct, Your Honor. The last point I would just touch on is in the closing pages of his brief, the defendant suggests that the verdict here was defective in some way, that the jury could possibly have relied on the firearm charge to convict of felony murder, and that this should really be a second-degree felony murder case. The instructions, if the court consults them, and the jury was instructed twice on felony murder, the instructions would not have permitted that. The instructions were only applicable to armed robbery or attempted armed robbery, and the jury would have had and the jury was in fact instructed that if you don't find the defendant guilty of felony murder in the first degree on a theory of armed robbery, you must acquit him of felony murder, and there simply would have been no basis for them to rely on the firearm charge. The only
Was the jury given a second-degree instruction?
the jury was given a secondary instruction on a sort of straight malice basis.
But no second-degree felony murder.
No secondary felony and murder, Your Honor. So I think it's quite clear that the jury, we don't need to know exactly why the jury acquitted on the armed robbery itself, but convicted on the felony murder. It was sufficient for them to have found that there was an attempted armed robbery, as the judge repeatedly instructed them and as the statute provides, and they were given a full instruction on attempt. So if there are no further questions, I'd rest on my brief.
The only question I had on there was there any evidence as to whether or not the defendant and his and Jigget actually got the marijuana?
There was conflicting evidence on it, Your Honor, that essentially the only evidence that they succeeded in carrying away the marijuana was Jigget's testimony. He said that they picked it up off of the ground, that they then took it with them on the bus to New York City, but it was never sold because the defendant's mother found it and threw it in the trash. He was, of course, a witness whose testimony was under attack the whole time. There was also marijuana found close to the victim's body.
Wasn't it quite a large part, a packet?
3 pounds or something?
There was a package found near his body. I don't remember the exact quantity. It wasn't 3 pounds. I think that was clear from the record. And 3 pounds was the amount that was negotiated. So.
Was Ms. Smith charged in this case?
Ms. Smith was initially under a cooperation agreement with the Commonwealth. She violated the cooperation agreement. She was prosecuted essentially for perjury and for interference with a police investigation, but not in this substantive crime. I believe that's correct.
Thank you.
Thank you, Your Honor.
Yes, counsel, you have 2 minutes.
Thank you. Very briefly, the defendant is not asking this court to rewrite Helfant. The defendant is asking this court to apply Helfant. And the concept of whether need should go into the calculus at least dates back to 1882 in the Jackson case, where the issue was counterfeit currency, and where the court indicated that the Commonwealth needed to look at prior bad act evidence because someone could inadvertently pass counterfeit currency, so there was a need for at least for that kind of that quality of evidence of prior bad act evidence. Yes, I'm asking to consider the need factor, but I would suggest it goes back in case law to the 1800s. Also, there is I cited in my brief. There's a recent, relatively recent article by Judge Agnes on basically taking the same position about the need going into discounting the probative value by the need for the government's need for the evidence. As far as the search goes, I would not. I don't think I would ever could, at least based on the record, that this was a more compelling emergency aid search than the Entwistle case. You did not have in the Entwistle case. You had the Matarazzo family appearing at the police department, saying, "Where's our daughter and our grandchild?" None of that was present here. And in the Entwistle case, there was no, that's part of the problem. In the Entwistle case, there was no criminal investigation at the time. Basically, it was a missing persons case. This case showed an active criminal investigation. And I think that is a significant difference.
Why was there not an appropriate concern that somebody had hurt her, taken her card, and was using her card, and that she was nowhere to be heard from for 24 hours?
Well, I think is that the concern, or was this a way around the Fourth Amendment? A way
You mean
around the
like a
requirement for a
pretext?
search? Certainly certainly would be a good, that's an excellent word, yes, pretext. That's probably the proper characterization from the defense standpoint. One last point. As far as the Pasco case goes, that's the case on abandonment. This law is not developed in Massachusetts. You have one appellate case from the appeals court, and then you have one case from this court. Again, I would suggest that just because someone flees the jurisdiction does not necessarily mean he abandons his property. If anyone were to be accused of fleeing, and I see my time is out, so I'm going to rest on my brief.
Thank you, sir.